Camera. Hi everyone. I hope I'm clearly audible and visible to everyone, of course. PDF is the PDF clearly visible to you all? Please confirm. Am I visible, audible, everything? Please confirm. Hi Anahit. Good evening, Rohit. Yes, Rohit, I'll share the Telegram channel of Divine Judiciary. I'll also give you the number. You can directly contact at the number. They're going to provide you a proper PDF of all the subjects, right? All the questions that I catered yesterday and I'm going to cater today. Okay. Hi, Ashan. Good evening. I hope you all are good. Are you all good, everyone? Please confirm. Please affirm. Good evening, Piyush. Okay. So I hope you all know what are we here for today. We'll wait for 1-2 more minutes for the students to join. Hi, Guncha. Hello. Hi, Puneet. I'm good, Rohit. Thank you for asking. Hi, Tanisha. Hello. Good evening, Sneha, Diksha. Good evening. Good evening. Good evening, Bhavya. Okay, we are waiting for some couple of more minutes, so maybe 1 or 2 more minutes, and then we'll start. You can just contact at the number for Divine. I'm going to give you the number while I end the session. So you can just contact there, and you're going to you're going to get the PDF via WhatsApp. Okay. Not audible. Please confirm, everyone. Am I not audible, or is there some difficulty in listening to me? Diksha, I think you need to check your connection. Thank you, Puneet, and everyone else. Perfect. Okay, Anjali. Thank you. Thank you all. Okay. I am just hoping and assuming everything that you liked yesterday's session, and I am honestly going to try to put my best foot forward and provide you with even better questions. And like obviously, I have had an encounter with a student, and I got to know that they want students, basically all of you want me to increase my speed a little, so I'll do that today so that we can cover more number of questions. Okay, so yeah, we'll start now. Okay, so the first question is here on everyone's screen. Can you all see this? Yeah. In the questions given below are two statements labeled as assertion and reason. I hope जिन्होंने एग्जाम दिया ना ईडीए का उनको पक्का पता है कि assertion and reasoning कितनी इंपॉर्टेंट रहती है. ठीक है, तो वैसे के दो तीन क्वेश्चंस आई हैव पुट फोर्थ, आई हैव ब्रॉट. आप देखिए, गुंचा आज ही किया है अभी, जस्ट नाउ. फर्स्ट क्वेश्चन फॉर एविडेंस एक्ट एवरीवन. द डेफिनेशन ऑफ, ओके, आपको बताना है क्या एजर्शन सही है, रीजन सही है, क्या एक दूसरे का एजर्शन जो है वो रीजन उसका सही है. द डेफिनेशन ऑफ एविडेंस अडॉप्टेड इन इंडियन एविडेंस एक्ट इज नैरो इन स्कोप, और इसका रीजन दिया गया है देयर आर सम लिमिट्स टू द फैक्ट्स दैट मे बी गिवन इन एविडेंस. तो आप बताएं क्या एजर्शन सही है, रीजन सही है. Both A and R are true and R is the correct explanation of A. Both A and R are true but R is not the correct explanation of A. A is true but R is false. A is false but R is true. Piyush says B. Okay, I'm waiting for everyone else's reply. Anahit says A. Keshav says B. Take your time, everyone. Sneha B. Okay. The correct answer to this one would be A. Okay, I'll tell you how. इन्होंने बोला है डेफिनेशन ऑफ एविडेंस जो है, जो इंडियन एविडेंस एक्ट में है, वो नैरो है. और उन्होंने दिया है, द रीजन इन्होंने दिया है क्योंकि जो फैक्ट्स जो कि एविडेंस में लिए जा सकते हैं उन पे कुछ लिमिट्स लगाई गई हैं. तो क्या ये रीजन सही नहीं है इसका? आप सब लोगों को लग रहा है इसका रीजन सही नहीं है ये सही स्टेटमेंट, बट दोनों का रीजन, इसका एजर्शन का रीजन नहीं है ये. अब तो नहीं लग रहा. दीपांशु ए, नंदनी ए, गुड. Guncha, it is A. Everyone else, can I move ahead? Acha, okay. I thought Piyush is saying कि नहीं ma'am, you can't move ahead. Okay, Piyush. Everyone else. Second question is here for everyone. In the questions given below are two statements labeled same question. Let us see. Assertion है provisions of Indian Evidence Act are not applicable to the proceedings before a commission of inquiry. And second है the proceedings before, reason क्या उसका दिया गया है, the proceedings before a commission of inquiry constituted under Commission of Inquiry Act are not judicial proceedings. आपके अकॉर्डिंग A and R are true but R is not the correct, R is the correct explanation. दोनों सही हैं but R is not the correct explanation. A is true but R is false. A is false but reason is true. What do you guys think? Please answer. Second question, everyone. क्वेश्चन नंबर 7 डालते जाएं एवरीवन. इट इज डेफिनेटली, इन्होंने बोला है नैरो स्कोप नहीं है युविना. उसका नैरो स्कोप क्यों बोला जाता है एविडेंस एक्ट का? इन्होंने हमें लिमिट कर दिया. ठीक है, अपने आप में तो एग्जॉस्टिव कर दिया, इससे बाहर चीजों को तो हमें रेलेवेंट मान भी नहीं सकते. ठीक है, हम उससे जितना हमारे को दिया गया उससे बाहर तो हम जा ही नहीं सकते ना यार. तो डेफिनेटली मीन्स एंड इंक्लूड्स तो है. ठीक है, एक एग्जॉस्टिव डेफिनेशन तो है, बट क्या वो एग्जॉस्टिव बना के इन्होंने गलती कर दी है? ये हम इसको ऐसे ले सकते हैं कि यार अगर ये एग्जॉस्टिव ना होती ना, या अगर इसमें और चीजें डाल सकते होते, या इसको खुला छोड़ देते, ओपन एंडेड छोड़ देते, तो एविडेंस एक्ट का स्कोप इतना लिमिट ना होता. ठीक है युविना, दिस वाज द एग्जैक्ट क्वेश्चन. दिस इज हाउ यू कैन इंटरप्रेट दिस क्वेश्चन. क्वेश्चन नंबर के साथ आंसर डालें सभी प्लीज, सो दैट इट बिकम्स इजियर फॉर मी टू अंडरस्टैंड कि आप लोग किसका जवाब दे रहे हैं. युविना, इज इट क्लियर? ओके ओके. अनाहित 2A, दीपांशु A, पीयूष A, गुंचा A. Perfect, everyone. Whoever has said A. I'm sorry. Yeah. इस केस में both A and R are true and R is the correct explanation of A. हम section 1 जब Indian Evidence Act का देखते हैं, you're going to find it there, right? ठीक है कि जुडिशियल प्रोसीडिंग्स पे लगता है और ये जुडिशियल प्रोसीडिंग नहीं है. whenever you going to find this question in your preliminary, you're going to be very happy कि हमने पढ़ रखा है. ठीक है, next. The tribunals are bound to follow what? Indian Evidence Act 1872, rules of natural justice, both A and B, none of the above. Everyone. Third question, quick. Anjali says C. Piyush C. Dipanshu B. Anahit B. अब आपको पता नहीं है? Okay. Sneha says C. Nandini C. Guncha B. Tanisha B. Riya C. Ashan C. जब हम सेक्शन 1 इंडियन एविडेंस एक्ट पढ़ते हैं, वहां पे वर्ड यूज है कोर्ट. तो डज कोर्ट इंक्लूड ट्रिब्यूनल? द आंसर इज नो. द आंसर टू दिस इज रूल्स ऑफ नेचुरल जस्टिस. द कोर्ट्स आर नॉट, ट्रिब्यूनल्स आर नॉट बाउंड बाय द प्रिंसिपल्स ऑफ एविडेंस एक्ट. Okay, next up. The Indian Evidence Act does not mention what? Indian Evidence Act does not mention relevancy of evidence, admissible evidence, weight of evidence, all of the above. Please confirm your answers. Guncha C, Tanisha C, Puneet C, Riya C, Sneha C, Anjali C, Nandini C. Perfect, everyone. All of you are correct. It is weight of evidence has nowhere been mentioned in Evidence Act. Perfect. Next up. Fifth question is here on the screens for you all. An inference of fact or law drawn from other known or proved facts is called? Everyone, please confirm your answers. Drop your answers quickly. For questions easy as these, I would expect you to be very quick. Guncha says 5A. Piyush says 5A. Dipanshu A. Anahit A. Anjali A. Sneha A. Rohit A. Okay. Is it A, everyone else? Jaldi kijiye. I'm waiting. The question is an inference of fact or law drawn from other known or proved facts. उस इन्फ्रेंस को क्या हम सर्कमस्टेंशियल एविडेंस कहते हैं? आप लोग ए कैसे बोल पा रहे हैं? मुझे समझ नहीं आ रही है. प्रिजम्पशंस नहीं है वो. आपने कोई चीज से कोई इन्फ्रेंस ड्रॉ कर लिया कि अच्छा अगर ऐसा हुआ तो ऐसा हुआ होगा. मतलब क्या हो गया? एवरीवन सब एक के पीछे लग जाते हैं. ऐसा ना करें ना आप ध्यान से देखिए कैसे हम, मतलब आई डोंट नो ये कंफ्यूजन कैसे आ गई आप लोगों को. आई होप अब आप ये गलती नहीं करेंगे ना. आई एम श्योर. आई मीन ओके. द आंसर टू दिस क्वेश्चन इज, sorry, how to do it. B is the answer, presumption. Anyway, we'll move ahead. Okay, so the next question is here for you all. The test to determine whether a proceeding is judicial or not is to see what? The test to determine whether a proceeding is judicial or not is to see whether the parties are entitled to the copies of the proceeding, whether the presiding officer is a judge, whether the parties are entitled as of right to be heard and to adduce evidence, none of the above. Which of the following is the judicial proceeding का essential एक तरह का? Quick everyone, I'm waiting for your answers. Okay, Tanisha C, Dipanshu C, अनाहित C, रोहित 5 में, अभी 6 पे आ जाइए फटाफट. ओके 6 का भी बी रोहित आपके अकॉर्डिंग. ठीक है, स्नेहा के अकॉर्डिंग भी बी, नंदिनी के अकॉर्डिंग सी. सी. आपको पता है क्वेश्चन क्या है रजय? क्वेश्चन इज विद रिगार्ड्स टू द टेस्ट टू डिटरमिन, राइट? तो इसका आंसर जो है वो आंसर सी है. उन्होंने पूछा है व्हाट इज द टेस्ट टू डिटरमिन की प्रोसीडिंग जुडिशियल है कि नहीं. उसका टेस्ट ये है कि क्या पार्टीज एज ऑफ राइट आर दे एंटाइटल्ड टू बी हर्ड, कैन दे गिव एविडेंसेस, तो मानेंगे एक प्रोसीडिंग जुडिशियल प्रोसीडिंग है अगर उस पार्टी वहां पे उस केस में एविडेंसेस दे सकती है और एविडेंसेस एड्यूस कर सकती है एंड इट्स द पार्टीज राइट टू बी हर्ड. ओके एवरीवन, विल मूव अहेड टू द नेक्स्ट क्वेश्चन. आप प्लीज डिमोटिवेट मत होएं जिन लोगों को ऐसा लग रहा है यार अभी तक सही नहीं हो रहे हैं. क्वेश्चंस कुछ बेसिक भी आएंगे, कुछ थोड़े से टेक्निकल भी हैं, बट आपका दिमाग खुल जाएगा इन सबको सॉल्व करके. आई एम श्योर उसके बाद ऐसा कोई क्वेश्चन रहेगा नहीं जो आपको पेपर में जाके ना आए. Okay, seventh question for you all. A is accused of the murder of B. At his trial, which of the following facts may be an issue? That A caused B's death and A intended to cause B's death. That A had received grave and sudden provocation from B. That A at the time of doing the act which caused B's death was by reason of unsoundness of mind, incapable of knowing its nature, all of the above. Everyone, quick, very easy, very easy. Riya says A, Piyush says D. Anahit says D. Puneet D. Sneha D. Keshav D. Guncha Parveen D. Okay. Correct answer is D only. Correct answer is D only. Perfect. We move on to the next question. Which of the following is a fact? ये आपने पढ़ रखी होंगी, जिन्होंने इलस्ट्रेशंस ध्यान से पढ़ी है ना उनको सारे आते हैं. That there are certain objects arranged in a certain order in a certain place, that a man heard or saw something, that a man said certain words, all of the above. Which of all do you think are facts? Or do you think all are facts? One of them is a fact. Please confirm everyone. 8th question for you all. 8 D. Okay. Piyush, Simran, Raman, Anjali, Keshav, Kuncha. Okay. 8th is D. Perfect, everyone. Very appropriate. 8 is all of the above. Perfect. Move on to the next question now. The definition of evidence in Section 3 of Indian Evidence Act has been amended by. The definition of evidence in Section 3 of Indian Evidence Act has been amended by Criminal Law Amendment Act 2006, Criminal Law Amendment Act 2010, IT Act 2000, NI Act 2002. What do you think? 9th question for you all. It's perfect everyone, perfect. Okay. The answer is C. Okay. We move on to the next question now. The standard of proof required in. सही आंसर बताइए इसमें से. Which is going to be the correct statement? Which is the correct statement as per your knowledge? Criminal cases is lower than in civil cases. Criminal cases is much higher than in civil cases. Civil and criminal cases is same. None of the above. 10th. Very easy. Tanisha says B. Gulleen says B. Piyush says B. Puneet says B. Okay. I hope you all are well aware कि burden of proof अगर देखे जाएं, burden of proof, standard of proving, burden of proof, standard of proving अगर देखे जाएं तो 4 तरीके से डिवाइड करे जा सकते हैं. 4 तरीके कौन से? सबसे पहले तो 2 तो हम जानते हैं ना. वो 2 कौन से हैं? हम जानते हैं यार, एक तो हो गया प्रीपोंडरेंस ऑफ प्रोबेबिलिटी जो सिविल केसेस में रहता है, ठीक है, और दूसरा होता है आपका बियॉन्ड रीजनेबल डाउट जो आपका क्रिमिनल केसेस में रहता है, राइट. आपको पता है सबसे पहले सबसे स्ट्रिक्ट क्या होता था? सबसे स्ट्रिक्ट होता था बियॉन्ड शेडो ऑफ डाउट, जो कहता था 100% प्रूव करो बियॉन्ड शेडो ऑफ डाउट। ठीक है, उससे थोड़ा हल्का आता था बियॉन्ड रीजनेबल डाउट, जो हम फॉलो करते हैं। नेक्स्ट आता था प्रीपोंडेरेंस ऑफ प्रोबेबिलिटी, उससे थोड़ा लाइट, जो हम सिविल केसेस में फॉलो करते हैं। और सबसे इजी और सबसे लाइट माना जाता था, सबसे फ्लेक्सिबल माना जाता था मियर बैलेंस ऑफ प्रोबेबिलिटी। मियर बैलेंस ऑफ प्रोबेबिलिटी मतलब 50-50 कर दो। ठीक है, तो हमने जो अडॉप्ट करे हैं सिविल और क्रिमिनल के लिए, हमने दोनों बीच वाले अडॉप्ट करे, ना ही ज्यादा स्ट्रिंजेंट स्ट्रिक्ट वाले और ना ही ज्यादा फ्लेक्सिबल वाला। हमने दो बीच वालों को अडॉप्ट करके क्रिमिनल एंड सिविल के लिए डाल दिया है। हम जानते हैं क्रिमिनल वालों के लिए इट्स मच हायर देन इन सिविल केसेस, so the correct option for this answer is, for this question is B. Perfect everyone, I'm moving to the next question. Facts which need not be proved by the parties include, please read. Facts which need not be proved by the parties include facts which have been admitted by the parties at or before the hearing, statements made on oath, any registered document, statement made in the plain or in the written statement supported by an affidavit. Please go with the most appropriate answer, everyone. Question number 11 for you all. 11A, A. Yes, Piyush, perfect. Okay, okay, everyone. The answer is A only, no doubt at it. Question number 11A. Okay, next question for you all is here. The term judicial proceeding is defined in section dash of Indian Evidence Act. Where is the term judicial proceeding defined in the act? Section 3, 4, 5, not defined. Guleen says D. Tanisha also says D. It is not defined anywhere. Is that the case, everyone? Raman says 3. D, not defined. Perfect, everyone. It is not defined anywhere. Okay, we move on to the next question with this. Which of the following is not a judicial proceeding? सेम क्वेश्चन प्री में आता है, बिल्कुल एग्जैक्टली सेम क्वेश्चन। इसमें तो आंसर्स भी ऑप्शंस भी बहुत कम बदलते हैं। An inquiry under 176, inquiry under 174, inquiry conducted by collector under Land Acquisition Act, all of the above. Which of the following is not a judicial proceeding? Gurman says C. Piyush says C. Keshav says C. Simran C. Guncha C. Raman C. Tanisha D. Sneha C. Gurleen Kaur C. The most appropriate answer for this question has to be all of the above. We do not consider all of these to be judicial proceedings for the purpose of Indian Evidence Act. So these are out of the ambit of being a judicial proceeding. Please mark it for your preliminary, everyone. Next question. Which of the following Law Commission reports deals with the Indian Evidence Act? Important question again. Which of the following Law Commission reports deal with Indian Evidence Act? Is it 49th, 41st, 69th or 59th? Piyush says 69th. Anahit says 69th. Sneha says it's C, 69th. Okay, perfect, everyone. The answer to this question is C only. 69th Law Commission report deals with Indian Evidence Act. Entire Indian Evidence Act was analyzed in this report of Law Commission. Okay, we move ahead now. In which of the following cases, 50th question for you all, in which of the following cases Supreme Court held that a tape recorded conversation is admissible as res gestae? Tape recorded conversation. Everybody think it is Kati Kallu. Everybody thinks appropriately. It's Kathi Kalu only. Perfect, everyone. Kathi Kalu versus, I'm sorry. It is Kathi Kalu versus State of Bombay. Perfect. Okay, we move ahead now. 16th. In order for the evidence to be admissible as part of res gestae, please read the options for yourself. The statement must have been made contemporaneously with the act. The statement must have been made made immediately after the act. The statement must have been made anytime after the act, either A or B. 16th, everyone. Okay, people are voting for D. Okay. Everybody think it is D. Everybody is right. 16th is D only. It can be the statement made which is made contemporaneously, and the second one is immediately after the act. Perfect, everyone. We move on to the next question with this. I hope आपका confidence अब थोड़ा boost हुआ होगा because अब आप लोग सही जवाब दे पा रहे हैं काफी हद तक. Starting वाले questions में there was a little dicey situation. Okay. Facts which are the occasion, cause or effect of facts in issue are relevant under. आंखें बंद करके नींद में भी जवाब दे सकते हैं इसको तो ना. Section 17, question 17. Okay, perfect. 17B, everyone. Perfect, perfect, perfect. Okay, we move on to the next question with this. The issue in question is whether A robbed B. Which of the following facts are relevant in prosecution of robbery against A under Section 7 of Indian Evidence Act? That shortly before the robbery, B went to a fair with money in his possession, that he showed the money or mentioned the fact that he had it to third persons, both A and B, none of the above. Which do you think are relevant under Section 7? Easy question. Again, Piyush says 18C, Anjali C, Nandini C, Anahit, Manveet. Okay, everyone thinks it is C. Perfect. The answer is C only. Both A and B are relevant facts according to section number 7 of Indian Evidence Act, everyone. So the next question is here for you all. The question in issue is whether A murdered B. Marks on the ground produced by a struggle at or near the place where the murder was committed are relevant facts under section dash of Indian Evidence Act. Under which section? 6, 7, 8, 9. Marks of struggle. सब लोग सी बोल रहे हैं. सेक्शन 8. सेक्शन 8 में आता क्या क्या एक बार मुझे भी बता दो सभी. सभी बताओ सेक्शन 8 में क्या क्या आता है. जो सी बोला है ना, सेक्शन 8 बोला है, वो सब बताएंगे इसमें आता क्या क्या है. नहीं, सी वाले पहले मुझे बताओ ना, सेक्शन नंबर 8 में क्या आता है. अच्छा, मोटिव आता है, ठीक है. प्रेपरेशन आती है और सबसीक्वेंट कॉन्डक्ट. मोटिव, प्रिपरेशन एंड कॉन्डक्ट, 3 चीजें आती हैं पीयूष. तो इसमें ये क्या है, स्ट्रगल मार्क्स क्या है, मोटिव है, प्रिपरेशन है कि कॉन्डक्ट है. मुझे कुछ नहीं नजर आ रहा. तो आप सब लोगों को कैसे लगा कि 8 में जा रहा है. एवरीवन, सेक्शन 7 में ही नहीं जा रहा. ये इफेक्ट नहीं है. इफेक्ट तो सेक्शन 7 में था. क्वेश्चन 19, एवरीवन. Okay, perfect, everyone. We'll move ahead. The answer is section number 7. Section number 7 only. Okay. Which of the following categories of facts which are completed within the transaction under inquiry are relevant under section 7 of Indian Evidence Act? Facts as being the occasion or cause of effect in issue and its effect. Facts as giving opportunity for the occurrence of facts in issue. Facts as constituting the state of things under which the fact in issue happened, all of the above. Very easy, very, very easy. Jaldi. Tanisha says D, Piyush D, Nidhi D, Simran D, Gurleen D, Sneha D, Anahit, Keshav, Priyanka, Piyush, Bhavya, Anjali. Perfect, everyone. Puneet, D. Okay. I'll go with everyone. Answer is D. Okay. Next. Proof of opportunity available to the accused to commit the crime is relevant under which section? You know it. Just show it. 1 second लगाइए, जल्दी करिए. आगे धीरे धीरे करके क्वेश्चंस टेक्निकल हो जाएंगे. जो इजी वाले हैं उन पे तो स्कोर कीजिए ना फटाफट. Okay, everyone thinks it's B. Okay, everyone, perfect. Next question for you all. The footprints of the accused near the scene of occurrence of the crime is relevant under which section of Indian Evidence Act? The footprints of the accused found near the scene of crime. Okay. Perfect, everyone. Perfect. It is C. It is section 7 only. Again. These were honestly, I was honestly intending to confuse you, but you are smart enough. Okay. Next. In which of the following cases did the Supreme Court hold a criminal trial is not an inquiry into the conduct of an accused for any purpose other than to determine whether he is guilty of the offense charged? In which of the following cases Supreme Court held that a criminal trial is not an inquiry into the conduct of an accused for any purpose other than to determine whether he is guilty of the offense charged? We have Palvinder Kaur versus State of Punjab, Anant Chintaman Lagu versus Bombay, Guddu versus MP, none of the above. Akash says 23A, Suman says A. Please write down the question number everyone side by side ताकि मुझे पता लगता रहे आप किसका रिप्लाई कर रहे हैं. हरसिमरन says A, Guncha says A, Manveet A, Manveet A, okay. पीयूष ए, निधि ए. हमें ना एक्चुअली पता क्या लगता है, हम सबको जो हमने केस लॉ सुने होते हैं ना, हमें लगता है हर किसी का आंसर वही है. ठीक है, तो जैसे पलविंदर कौर आप सबने कन्फेशन में सुना होगा, है ना, लेकिन इसका आंसर है अनंत चिंतामन लागू वर्सेस स्टेट ऑफ बॉम्बे. एवरीवन, ठीक है, अब याद रखें इसे. Perfect, Piyush. Amazing. Next question for you all is here on the screens. Absconding of the accused is a fact relevant under which section of Indian Evidence Act? Absconding of the accused. Jaldi, easy again. Sandeep says 24B. Puneet says C. Tanisha C. Nidhi C. Nandini C. Priyanka section 8. Gurleen C. Okay, perfect, perfect, everyone. It is subsequent conduct. Perfect. We'll move ahead now to the next question. Things said or done by a conspirator in reference to common design is a relevant fact under section dash of Indian Evidence Act. Very easy again, section based question. Take 1 second, answer it for me. 25. 25C, 25D, 25C, A, D, D. Section 10, everyone. Perfect. The answer to this question has to be section 10. अच्छा, कॉन्स्पिरेसी डिफाइंड कहां पे है? कहीं पे डिफाइंड है? कॉन्स्पिरेसी के और कौन सी प्रोविजन यहां से लिंक कर सकते हैं सेक्शन 10 के साथ? इंडियन एविडेंस एक्ट की बात नहीं करी, जनरली पूछ रही लॉ में. वन 120 AIPC. Perfect, perfect, everyone. Okay, we'll move ahead to the next question now. अच्छा, by the way, before I move ahead, can you please tell me कि एफिडेविट एविडेंस होता है क्या? एफिडेविट एविडेंस होता है क्या? बताइए. Sandeep says no, Akash says yes, Bhavya says no. No, 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 no. Okay, इसकी कोई exceptions है? To this general rule कोई exception? Guleen says unless permitted. Perfect. Order 19. Perfect, perfect. सीपीसी में तो ऑर्डर 19 हो गया. ऑर्डर 19 रूल 3 सीपीसी ट्रिवियल मैटर्स में. ठीक है. सीआरपीसी में कहीं पे है क्या? सीआरपीसी में कहीं पे? जनरली इज नो. आई नो जनरली सेक्शन 1 इंडियन रेवेन्यू एक्ट. आई नो एक्सेप्शंस पूछा मैंने. ओके 285 सीआरपीसी. व्हाट अबाउट 295, 296, 297 सीआरपीसी? Everyone, mark these. These are the exceptions. We'll move ahead now. Perfect, Piyush. Yes. We move ahead now to the 26th question, which is here on your screens, where there is a reasonable ground to believe that two or more persons have conspired together to commit an offense or an actionable wrong. Options: anything communicated between them in reference to their common intention after the time when such intention was first entertained by any one of them is a relevant fact as against each of the persons believed to be so conspiring. Anything said, done, or written by any one of such persons in reference to their common intention. Communicated to all of them. It has to be intention, which has to be here. I'm sorry. After the time when such intention was first entertained by any one of them is a relevant fact as against each of the persons believed to be so conspiring. Next, we have anything said, done, or written by any one of such persons in reference to their common intention after the time when such intention was first entertained by any one of them is a relevant fact as against each of the persons believed to be so conspiring. थोड़ा थोड़ा फर्क है, जल्दी देखिए. 26. Everyone. 26C. Fit India says C. Sandeep says B. Tanisha says C. Keshav says C. Bhavya C. Perfect. C is the correct answer, everyone. 26C. Okay, we'll move ahead. An admission constitutes, important question again. An admission constitutes a substantive piece of evidence, corroborative piece of evidence, secondary evidence only, none of the above. An admission constitutes a dash. Substantive piece of evidence, corroborative, secondary, none. Pew says A. Ram says A again. Suman A. Bhavya A. Keshav A. Tanisha A. Nidhi D. Hemant B. Okay, the answer for 27 has to be A, everyone. An admission is a substantive piece of evidence. It is definitely not a conclusive proof of something, but it is definitely a substantive piece of evidence. All right, everyone. We move ahead now to the next question. Which of the following is not defined in Indian Evidence Act? Admission, confession, both, none. Which of the following is not defined in Indian Evidence Act, everyone? 28. Be quick. 28C says Sandeep. 28B says Harsimran. 28B, B, B. People are rooting for B a little more. D, C. Anahit says D. And Nandini says C. Puneet says C. Nandini, B. Okay. Okay. The answer has to be B. Admission is defined, yaar. Section 17. Confession is nowhere defined. सीधा ये स्लाइड करते हैं 24 में, कन्फेशंस में घुस जाते हैं और हमें पता भी नहीं लगता. ठीक है? ओके. Next question for you all. Section 15 of Indian Evidence Act deals with the rule of relevancy in cases where the question is whether the act is rash or negligent, accidental or intentional, with motive or without motive, all of the above. Question number 29 on your screens, everyone. Nidhi says 29B, Pew says B, Ram says B. Okay, perfect. It is B. No. It has to be D, everyone. It has to be D. Rash or negligence, intention, non-intention, motive, without motive. 15 deals with all of them. It is D, everyone. पीयूष ने बोला बी को लॉक कर दें. Piyush, it's D. Wait. Wait. Am I mixing things? We realize where the question is whether act is accidental or intentional. I'm sorry, it has to be B. I'm sorry, I was reading it the other way. Okay. Not working. Accidental or intentional has to be the correct answer. Most appropriate answer के साथ जाएं तो वही बन रहा है. Okay, go with B. Okay, we move ahead now to the next question. In order to be relevant under Section 15 of Indian Evidence Act, it is necessary that all the acts have to form part of the same transaction. All the acts have to be part of series of similar transactions. The accused has been convicted for similar transactions, none of the above. जी पीयूष आप जीत गए हैं. 30 is B, everyone. Perfect. 30 is B. Okay, we move ahead to the next question. The question is whether a particular letter was dispatched. The fact that it was in the ordinary course of business for all letters put in a certain place to be carried to the post, and that the particular letter was put in that place are relevant under section dash of Indian Evidence Act. इस एक्ट को रिमूव कर दीजिए. ये वर्ड जो है रेलेवेंट है इसको अब छोड़ दीजिए. इसको रीड करिए. आर रेलेवेंट अंडर दैट सेक्शन. 31 Puneet says B. Sneha says I am unable to understand your answer. Bhavya B. B. 31. 31 का answer has to be B, everyone. It is section number 16. Okay, we move ahead now. Which of the following sections of Indian Evidence Act deal with presumption related to common course of business? Presumptions related to common course of business. आपको सबको पता होगा 114 की सारी illustrations कितनी important है. Clauses याद करने पड़ेंगे उनके. 32 everyone. Tanisha says 32A. Fit India says C. Sneha says A. Keshav says A. Bhavya says A. The answer has to be 32D, everyone. 114F. Okay, perfect, Piyush and everyone else. We move ahead now. The statement which suggests any inference as to any fact in issue or relevant fact is called. Any inference as to any fact in issue or relevant fact is called. Suman says A, Ritesh A, Keshav A, 33A, Puneet says A, Nidhi A, Piyush A, Bhavya A. Okay, perfect, everyone. The answer has to be A. Okay, we move on to the next question with this. Admission is defined in which section of Indian Evidence Act? You know it. Admission is defined in which section of Indian Evidence Act, everyone? The answer has to be section number 17. Perfect. We move ahead with this. The definition of admission under 17 has been amended by Criminal Law Amendment Act 2005, IT Act 2000, ID Act 2008, none of the above. Please confirm, everyone. The definition of admission has been amended by what? B. Okay. Yes, the perfect answer has to be 35B. IT Act 2000 brought an amendment into Section 17. Okay. The basic idea embedded in Section 27 of Indian Evidence Act is the doctrine of necessity, confirmation by subsequent events, agency, none of the above. Basic idea in under Section 27. This is question number 36, everyone. Mankesh says 36B, Harsimran says B, Puneet B, Anahit B, Piyush B, Fit India B, Bhavya B. Perfect, everyone. It has to be the doctrine of subsequent events. It basically means statements that are made in custody they have to be admissible to the extent that they can't be proved by subsequent discovery of they can be proved by subsequent discovery of facts. Okay, we'll move ahead. The answer has to be confirmation by subsequent events. So the next question is here on your screens, everyone. In which of the following cases was it held that the expression fact discovered under 27 of Indian Evidence Act includes not only the physical object produced, but also the place from which it is produced and the knowledge of the accused as to that? Please confirm, everyone. 37. 37, Harsimran says A, Mankesh A, Nandini A. Perfect, everyone. 37 is A only. This is a case of Muhammad Inatullah versus State of Maharashtra. Perfect. Which of the following sections is a proviso to section 25 and 26 of Indian Evidence Act? Which of the following is a proviso, everyone? 38. Okay, 38. Everybody thinks it's C. Perfect. C has to be the proviso, everyone. Okay. Which of the following law commission reports suggested a repeal of section 27? Which law commission report suggested that 27 should be repealed? $39. Okay, please try giving answers, thinking about it. Nidhi thinks it's D. She's asking. Yes, it's difficult, I know. It's new for you all. The answer has to be 152nd Law Commission report, everyone. It was suggested in this report that 27 should be repealed. Okay, next up. Again, a little technical question. The doctrine of confirmation by subsequent events was first laid down in which case? The doctrine of confirmation by subsequent events. Is it Baskerville? Is it Warwickshire? Is it Kotaya case? None of the above. Okay, 40. Mankesh says it's C. Puneet C. Piyush A. Anahit B. Nidhi C. Simran Thakur Baskerville. Guncha C. Mankesh C. Okay. The answer for everyone has to be 40B. It is Warwickshire. R versus Warwickshire was the case. Everyone. Okay. We move ahead. Nothing in the section shall be deemed to apply to any of the statement deemed to apply to any statement falling within the provisions of clause 1 of 32 of Indian Evidence Act or to affect the provisions of section 27 of that act. The above wordings are from which section? Everyone, interesting question. You will only be able to answer it if you are well aware of 161, 162, CRPC, 24 and 25. You are well aware of all the laws. Nothing in this section shall be deemed to apply to any statement falling within the provisions of clause 1 of section 32 or to affect the provisions of section 27 of that act. Nandini D, Tanisha D, Suman D, Piyush. Yes, 162 CRPC. Piyush. Perfect, Piyush. Okay, everyone else. Amazing, amazing, amazing. The answer has to be 162 CRPC. Okay, we'll move ahead with that. Dying declaration are relevant in criminal, civil, both? None. Everyone, quick. Dying declarations are relevant in civil, criminal, both, none. Okay, Tanisha says 42A. Somebody is saying C. Nandini C. Has 42 has to be C, both A and B, everyone. Both A and B. Perfect. Statement of the deceased about the transaction which resulted in the death of her sister is admissible as a dying declaration. Please, these words are a little misarranged. Is admissible as dying declaration, is not admissible as dying declaration, depends, none of the above. What do you think? 43, everyone. Puneet says B, Tanisha B, Bhavya A, Tamanna A, Fit India B. The answer has to be B, everyone. Is not admissible as a dying declaration. Okay, with that we move ahead. The question is whether A and B were married. The fact that they were usually received and treated by their friends as husband and wife is relevant, irrelevant, depends, none. 44, everyone. Sneha A, Rachna A, Puneet A, Piyush A, Mankesh A, Nidhi, Suman, every Tamanna, everyone, it's A only. Relevant, perfect. The person who makes a dying declaration must be in a fit condition, may not be in a fit condition, depends, none of the above. 45 for you all. 45, yes. Rachna A, Gulleen A, Tanisha B, Gulleen, okay. Piyush B, Suman A, Nandini B, Anjali A, Anahit B, Piyush B, Tamanna B, Mankesh A, B. The answer has to be A. It is not with regards to physical inability. Okay? Has to be fit, mentally fit to give a declaration, to state something. Okay? Next. Dying declarations are relevant under which section of Indian Evidence Act? Be quick. You know this, very easy. Mentally fit, Piyush. Thirty-two one, everyone. 32 1. 46A, 46A. Okay, perfect, everyone. We move ahead with that. A has obtained a decree for the possession of land against B. C, B's son murders A. In consequence, the existence of the judgment is irrelevant, relevant to prove the intention, relevant as showing motive for a crime, none of the above. Everyone. 47. Tanisha says 47B. Fit India says C. Anahit C. Suman C. Piyush C. Guncha B. Simran C. Sneha C. Bhavya C. Okay, perfect. The answer has to be relevant as showing motive for a crime. Okay, everyone, we move ahead with this question. A is charged with theft and with having been previously convicted of theft. The previous conviction is relevant as a fact and issue, is not relevant as a fact and issue, is not relevant and admissible, none of the above. His previous conviction. Question number 48 for you all. Puneet says A, Piyush A. The answer has to be A, everyone. It is relevant as a fact and issue. Perfect. Expert opinion is relevant under which section of Indian Evidence Act? Expert opinion. Forty-ninth. The answer is D. Perfect. Okay, we move ahead with that. Which of the following has been termed as second-hand secondary evidence by the Supreme Court? Important again. Second hand secondary evidence. Which of the following has been termed so by the Supreme Court of India? Sneha says B, Piyush says A, Bhavya B, Rachna C, Legal Studies B, Harsimran D, Totu 50B. Okay, A, B, C, B, A. Okay, the answer has to be B. Newspaper report has been held to be second-hand secondary evidence by the Honorable Supreme Court of India. Okay, we move ahead with that. Relevancy of opinion on handwriting is mentioned in which section? Relevancy with regard to handwriting, everyone. 51. Okay, it is section 47. और कहीं पे हैंडराइटिंग की बात हुई है क्या? और कहीं पे हैंडराइटिंग की बात हुई है क्या? परफेक्ट 73 अमेजिंग ठीक है ओके परफेक्ट आगे चलते हैं नेक्स्ट क्वेश्चन फॉर यू ऑल when the court has to form an opinion as to the person by whom any document was written or signed, the opinion of any person acquainted with the handwriting of the person by whom it is supposed to be written or signed, that it was or was not written or signed by that person, is a relevant fact, not a relevant fact, not relevant and admissible, none of the above. 52nd question for you all. Bhavya says A, Gulin says A, Piyush A. Everyone else, it's just A for you all. Simran, Jairath A, Anahit A, Suman A. 52 has to be A, everyone. Easy question again. Okay, next. A person is said to be acquainted with the handwriting of another person when he has seen that person write, when he has received documents, when in the ordinary course of business, documents purporting to be written by that person have been habitually submitted to him, either A or B or C. 53 for you all, easy. Tanisha says D, Harsimran says D, Rachna D, Simran Sneha, everyone says D. So I would say D as well. Okay. Facts admitted need not be proved. This is provided in which section of Indian Evidence Act? Facts admitted need not be proved. 56, 57, 58, 59. This is question number 54, 54 for you all. Okay, everyone thinks it's C. Okay, it's C, everyone. Section number 58. Okay. Section 58 of Indian Evidence Act deals with what? Judicial, extrajudicial admissions, both, none. Easy question again, 55 for you all. $55. Please write the question number side by side, everyone. It's a request again. The answer in this case has to be the answer in this case has to be 50 has to be judicial admissions, everyone. ठीक है 58 में judicial admissions की बात करी गई है. Okay. Section 58 of Indian Evidence Act is applicable to civil, criminal, both, none. Civil, criminal, both, none. 56. Civil, criminal, both, none. Please, everyone. 56. Be quick. C, C, C. Okay, it has to be C, everyone. 56 is C, both civil and criminal cases. Perfect. With that, we move to 57. The court may in its discretion require the facts admitted to be proved otherwise than by such admissions. The statement is true, false, partly correct, none. A, true, 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 true. Okay, perfect. It has to be true, everyone. Easy. It was an easy question, very easy question. Which of the following admissions are dealt with by Section 58 of Indian Evidence Act? Admission in pleading, admission which can be implied from the pleading, admission by parties or agents at the time of hearing, all of the above. कौन सी तरह की admission 58 में covered है? जल्दी बताइए, everyone. 58. Piyush says D, Bhavya D, Sneha D, Simran D, Suman D, Anjali D, and Ahid D. Okay, everyone says it's D. 58. Okay, perfect. Perfect, everyone. It has to be D. Okay, with that we move ahead. Chapter 4 of Indian Evidence Act deals with what? Oral evidence, facts that need to be proved, need not be proved, documentary evidence, none of the above. 59, everyone. Okay, perfect, perfect, perfect. Oral evidence. Next, public documents are defined in which section? Public documents, question number 60. Perfect. It is 60C. Section number 74. Easy. Which of the following is a public document? Documents forming the acts or records of the acts of the sovereign authority, documents forming the acts or records of the acts of official bodies and tribunals, document forming the acts or records of the acts of public officers, legislative, judicial, and executive of any part of India, all of the above. D, everybody said D. Okay, perfect. The answer has to be D here. No denying this fact. Okay. Public records of private documents kept in any state are public record of private document kept in any state are public, private, unofficial, none. 62 easy, everyone. 62A, Harsimran A, Tanisha, Simran, Gurleen, Suman, Piyush, Sneha, Anahit, Deep. Okay, okay, okay. Yes, it's A, everyone. It's A. They are going to be public documents. Okay. Private documents कहाँ पे defined है? फटाफट बताना. 63. Private documents कहाँ defined है? 72, 73, 74 or 75? Question number 63. D. Okay. Perfect, perfect, everyone. 63 has to be D. Okay. Which of the following is the public document? FIR, charge sheet, judgment, all. Which of the following is the public document, everyone? Okay, okay, everybody thinks it's D. So I'd go with D as well. Perfect. Okay, we move ahead now. The modes of proving the content of various official documents are given in section dash of Indian Evidence Act. The modes of proving the content of various official documents. Please answer, everyone. I hope this session has not been very tiring for you as of now. Are you taking it easy? Yesterday we were able to cover 100. We are going to cover 120 today. All right. (65A). Perfect, everyone. (66). An act, order, or notification of the state government may be proved by oral evidence, journals publishing those documents, the records of the department certified by the heads of department, or by any document purporting to be printed by an order of the government. None of the above. We are talking about an order or notification of the state government, everyone. 66. Thank you, Rachna. Thank you, Guncha. It will be really kind of you all if you could all just comment once the session is over on YouTube, I'll be grateful to you all. Okay, 66. Everyone thinks it's C. Okay, it's C only. Amazing. Okay, perfect. We move ahead with that. Under section 77, copies may be produced in the proof of contents of. कौन से डॉक्यूमेंट्स के प्रूफ में हम कॉपीज लगा सकते हैं 77 के अकॉर्डिंग? पब्लिक, प्राइवेट, अनऑफिशियल, नन. पब्लिक, प्राइवेट, अनऑफिशियल, नन. The answer has to be 67 का A, public documents. Perfect. Next question for you all is on your screens right here. Presumption as to genuineness of certified copies is contained in section dash of Indian Evidence Act. Presumption as to genuineness of certified copies. Yes, 68 ka, it has to be B, everyone. Section 79. Presumptions तो हम जानते हैं 3 तरह की होती है ना. May, presume and shall. तो मे में कौन कौन सी आ जाती हैं? मे में हमारे पास सेक्शन 87, 88, 86, 90, 114, 113A ये आ जाती हैं. तो टेक्निकली 86, 87, 88, 90, 113A, 114 आ जाता है. कॉन्क्लूसिव प्रूफ कितने हैं हमारे पास पूरे इंडियन एविडेंस एक्ट में? आप बताएंगे मुझे कितने सेक्शंस हैं कॉन्क्लूसिव प्रूफ के और कौन कौन से? 3 सेक्शंस है. कौन कौन से हैं 3 सेक्शंस? एवरीवन. (41), 112, 113. Very quick and I appreciate that everyone. Amazing, amazing. Next. शैल में कितने हैं? नंबर नहीं, मुझे रफ आइडिया दे दो शैल में कौन कौन सा आता है. 79 to 85 तो सीधा सीधा आ जाता है ना? Amazing. I'm proud of you all already. 79 to 85, then 89. एक 105 आता है क्या शैल में? ओके, परफेक्ट तनीषा. 105 आता है क्या एवरीवन? 113B, परफेक्ट. 114A. ओके, अमेजिंग अमेजिंग. 111A, एवरीवन. ये सारी बन जाती है हमारी शैल प्रिज्यूम्स. ओके, परफेक्ट. वी मूव अहेड विद दैट. The burden of proof as to any particular fact lies on the person who wishes the court to believe in its existence, unless it is provided by any law that the proof of that fact shall lie on any particular person. This is contained in which section of Indian Evidence Act? 69th question for you all is here on your screens. (69C), C, D, C, A, C, 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 103, C. Is this line quoted in 101? Everyone. Nandini Sneha, is it quoted in 101? It is not quoted in 101. This exact line is quoted in 103, everyone. Section 103. We'll move ahead with that. When a person is accused of any offense, the burden of proving the existence of circumstances bringing the case within any general exceptions in IPC or without any special exception or proviso contained in any other part of the same code or in any law defining the offense is on the prosecution, accused, police, none. Very, very easy. 70. Perfect view. Section 105, 105. It has to be on the accused, everyone. Amazing. Okay, with that we move ahead. Which of the following sections of Indian Evidence Act deals with burden of proving that the case of the accused comes within exceptions? अभी हमने देख ही लिया है. We know the answer already. It is section 105. Okay. Presumptions under section 11, 111A are applicable to offences under section dash of Indian Penal Code. Presumptions under 111A are applicable to offences under section dash of IPC. जल्दी बताइए. Interesting question again. 72. Puneet says A, Harsimran A, Tanisha A, Fit India A, Piyush A. The answer Keshav, Rachna, everyone. It has to be A. Perfect. Okay. Which provision of 5 Indian Evidence Act provides that birth during marriage is conclusive proof of legitimacy? Birth during marriage is conclusive proof of legitimacy. Which section? 73C, everyone. C. Okay. Yes, it is 73C, 112, everyone. Perfect. With that, we move ahead. Birth during the continuance of a valid marriage or within days after its dissolution and the mother remaining unmarried shall be conclusive proof of the legitimacy of the child born. Within how many days, I mean? Within dash days is the question. After its dissolution. 280, Simran says 280, Piyushi 280. Do you see all things C? Okay, perfect everyone. C has to be the answer. Okay, with that we move ahead. Unless non-excess is proved, the presumption as to legitimacy of any child born during continuance of a valid marriage between his mother and any man is a rebuttable presumption of law, a presumption of fact, conclusive proof, none of the above. Puneet says C, Nandini C. Okay, perfect. We did discuss it, Abhi. It has to be a conclusive proof. Perfect. When a person does an act with some intention other than that which the character and circumstances of the act suggest, the burden of proving that intention is upon. बताइए. एनडी तिवारी लैंडमार्क. Perfect, Piyush. Yes, when a person does an act, everyone, is it visible? Perfect. It has to be that person. Section 106 की illustration नहीं है ये? I think, as far as I'm able to recall, it is illustrations. 76 की. Sorry, 76 बोल रही हूँ. 106 की. Can we move ahead, everyone? Okay. Which of the following sections of Indian Evidence Act deal with estoppel of tenant and of license of a person in possession? 77 for you all. Be specific, everyone. Don't give me 115. No. Everyone, it is 1-1. Which one should I go with? Okay, perfect. It has to be 77C. 116. No tenant of immovable property or person claiming through such tenant shall, during the continuance of the tenancy, be permitted to deny that the landlord of such tenant had, at the beginning of the tenancy, a title to such immovable property. The statement is true, false, partly correct, none. Nidhi says 78A. Everyone else says true. Perfect. It's easy. It's A only. We move ahead with that. Which of the following sections of Evidence Act deals with estoppel of an acceptor of bill of exchange, a bailee or a licensee? Very easy again. 79 for you all. It has to be D. Perfect. 117. Okay, we move ahead with that. The competency of a child witness can be tested by. Little tricky, but something new to learn. The competency of a child witness can be tested by Evideer test, Void Dyer test, McNaughton's, and none of the above. 80. B, C, B. Anjali C, Zanisha B, Hina B, Simran McNaughton's. Simran, wasn't that for insanity? Keshav C, Piyush B, Harsimran D. Okay, this answer has to be void dire test, everyone. Something new for you to learn. The competency of a child witness can be tested by void dire test, which basically directed कि you have to like test the veracity of the child or test the what do we call it? The competency of a child by asking that preliminary inquiry करके you have to like talk to the child and get to know, ask him questions not related to the fact and general questions etc. यहाँ पे था void dire test everyone. 81. The order in which witnesses are produced and examined shall be regulated by the law and practice for the time being relating to civil and criminal procedure, respectively, and in the absence of any such law by prosecutor, defense, direct discretion, none. 81. Thank you, Totu. Nishikant Jhavar Zero Bihar, okay. Child is a competent witness. Yeah. 81. Tanisha says C. Everyone else says A. Tamanna C. Suman C. Puneet C. Rachna C. Nidhi C. Okay. 81C. Perfect, everyone. It has to be discretion of the court. Okay, with that, we move ahead. A lunatic is competent during lucid intervals. What kind of witness is a lunatic? 82. C, 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 C. Perfect, everyone. It is C only. 82. C. Competent during lucid intervals. Okay. When either party proposes to give evidence of any fact, the judge may ask the party proposing to give the evidence the manner in which the alleged fact, if proved, would be relevant, and then the judge shall admit the evidence, irrespective of whether it was relevant or not. If he thinks that the fact, if proved, would be relevant and not otherwise, it is the discretion of the court, none of the above. एक पार्टी है प्रपोज करिए कोर्ट को एविडेंस देना चाहती है, द जज मे आस्क द पार्टी प्रपोजिंग कि एविडेंस दे दो. ठीक है, प्लीज बताइए इसका आंसर. क्या जज एडमिट ऐसे ही कर लेगा रेलिवेंसी को इग्नोर करके? तमन्ना says B, Harsimran B, Keshav C, Piyush B, Anjali B. 83 has to be B, everyone. He'll only do that. He knows it is going to be relevant only then he's going to consider that. 84, everyone. Move to the next question. 84 on your screens now. In which order does the examination of witness take place? Very, very easy. Court examination, chief examination, cross examination and examination chief, examination in chief, cross and re, none. 84 for you all. Everyone says C. Perfect. I go with C as well. In chief, cross and re. Okay. Under which of the following sections of Indian Evidence Act is the evidence of a dumb witness taken into consideration? 116, 117, 118, 119. Evidence of a dumb witness. 16, 17, 18, 16, 117, 118, 119. 85. Tanisha says D. Parveen says B. Nidhi, 85D. Harsimran D. Okay, the answer has to be D, everyone. The answer has to be D, 119. Which of the following sections of Indian Evidence Act deals with witness to character? Witness to character, everyone, 137, 138, 139, 140. Please answer for me, everyone. '86 on your screens. D, 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 C, D, 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 D. Okay. I'd go with D as well. It is 140, everyone. Perfect. A leading question without the permission of the court may be asked during examination in chief at any time, cross none. A leading question without the permission of the court. C A C C. Be quick, it's an easy question, everyone. Cross C C. Okay, perfect. It has to be cross examination. Okay, with that we move ahead. Which of the following sections of Evidence Act defines examination in chief, cross and re? Define कहाँ पे करेंगे ये तीनों चीजें? फटाफट. Easy again. 88. It has to be 137. Perfect. Okay. The adverse party may further cross-examine upon a matter in the re-examination if new matter is introduced by permission of the court, both none. Good question. Important as well. '89. Okay, C. Perfect, everyone. It has to be C. Okay, with that we move ahead. Which of the following is not provided in Indian Evidence Act and CRPC? Giving up a witness, tendering a witness for cross-examination only, examination of the accused as a witness, none of the above. Question number 90 for you all. Perfect, everyone. It is tendering a witness for cross-examination only. Okay. Which of the following is true and correct? A person summoned to produce a document does not become a witness by the mere fact that he produces it. A person cannot be cross-examined unless and until he is called as a witness. Both none. Perfect, Piyush, Puneet, Jarath, Simran, Sneha, Fit India, Tamanna, Keshav, Pavan. Anjali thinks it's A. Right, go with C. Both A and B, everyone. Has to be the correct answer. Which of the following statements can be used to corroborate the maker as provided under section 157? FIR, dying declaration, declarants, dying declaration if the declarant survives, statement recorded under 164, this under has to be here, if there has to be here, I'm extremely sorry, all of the above. There has been some printing error. I mean, I don't know how did it catch like that. 92. D. Okay. Perfect, everyone. 92 has to be D. All of the above. Which of the following statements cannot be used to corroborate the maker as provided under section 157? Cannot be used. Statement in inquest, statement under 161, both none. '93 for you all. 93 has to be C. Amazing. Both of these cannot be used to corroborate. Next question. A witness can be allowed to refresh his memory by referring to any writing made by himself at the time of the transaction concerning which he is questioned or so soon afterwards that the court considers it likely that the transaction was at that time fresh in his memory as provided under section dash of Indian Evidence Act. This is the question in front of you all. 159, 156, 155, 157. 94. A. Perfect. It is A, everyone. 94 is A. Section 159. With that, we move ahead. Which of the following is correct? A police officer can refresh his memory. Okay, this is again a shuffling of words. A police officer can refresh his memory from a previous recorded statement under section 162. This is jumble the words we are playing side by side. A witness can refresh his memory from his previous statement recorded in the 162. पहला है कि police officer can refresh his memory. Second है witness can refresh his memory using both are using the statements under 162 CRPC. Both none. Which of the following is correct? Harsimran C, Tanisha C, Gunjan isn't replied yet. Okay, Anjali C, पीयूष ने क्या जवाब दिया 95 का? सी, केशव ने सी, भाव्या ने बी दिया है, स्नेहा सी, पुनीत सी. The answer has to be C, everyone. Okay. The judge's power to ask questions is provided under which section of Indian Evidence Act? Judge's power to ask questions. 96. B, C, okay. 96 has to be C, everyone. Easy question. 165, C, Evidence Act. A doctor can refresh his memory from a post-mortem report. The statement is true, false, partly correct, none. 97 for you all. Knowledge Vista A, Suman C, Bhavya A, Nidhi A, Puneet A, Sneha A, true, true. Okay, everyone, it's true only. Okay. In which of the following cases did the Supreme Court hold the investigating officer should be allowed to refer to the records of investigation? State of Karnataka versus Yerappa Reddy, Mohammad Khalid versus West of Bengal, Baburam versus Uttar Pradesh, Rajasthan versus Om Prakash. Knowledge Vista says A, 98 A, Piyush says A, Bhavya A, everyone has to say A, Guncha says C, Sneha B, Tanisha D. Okay, the answer has to be A, everyone. State of Karnataka versus Yerappa Reddy is the right answer for this question. Okay, with that we move ahead. A false answer offered by an accused in statements under section 313 of CRPC can be counted as a missing link in completing the chain of circumstances, can be used as substantive evidence against him, depends on the facts and circumstances of the case, none of the above. A false answer by an accused under section 313 CRPC. Puneet says D, Harsimran A, Tanisha B, Piyush A, Toto D, Piyush D, Suman D, Piyush, none of the above. Mani D, Sneha B. Okay. Question number 99, the most appropriate answer has to be A, everyone. It can be counted as a missing link in completing the chain of circumstances. This is the most appropriate answer. Okay, we move ahead with that. Which of the following is correct? Suspicion, however strong, is not a substitute for legal proof. Graver the charge, the greater has to be the standard of proof. There is a long mental distance between may be true and must be true, all of the above. Okay, Sandeep says it's D. Sneha D, Bhavya D, Piyush D, Knowledge Vista D, Fit India C. Puneet, which question are you talking about? Simran D, Piyush D. Okay, everyone think it's D. D is the correct answer only, everyone. Perfect. ये वाली जो लाइन थी ना, लॉन्ग मेंटल डिस्टेंस बिटवीन मे बी ट्रू एंड मस्ट बी ट्रू, इसकी एक लैंडमार्क जजमेंट भी है, किसी को याद है? ये लाइन कौन सी जजमेंट में बोली गई थी? Anyone? If you. It was Sarwar Singh versus State of Punjab, everyone. It is a landmark judgment. Sarwar Singh versus State of Punjab in 1957. Can we move ahead, everyone? We are done with 100 questions already. We are left with 20 more for today. I hope you all are not tired. All are good. Okay. Only I think Piyush is excited and is perfect. All other have lost their track. I'm waiting for you all to reply so that I can move ahead, everyone. I can't see who's like giving me 100. What is this? I don't know. All good. Sandeep. Okay. Simran, no. Rachna, good. Perfect. Okay. I'm going to continue. Perfect. Okay. Okay, Tanisha. Amazing. Thank you. Okay, Anjali's tired. 20 more questions. We are not far. You're not that far. You have reached. Okay, okay, perfect, everyone. I'm glad that you all are equally excited as I am. Okay, we move on to 101. In which of the following cases the Supreme Court held that the evidence relating to electronic record being a special provision, the general law on secondary evidence under section 63 read with 65 shall yield to be the same? 101. Yes, Anjali. 120 for today, Guncha. I've planned 120 for today, honestly, because I was able to complete 100 yesterday. So I was able to like rationalize कि यार 120 ही is good enough for 2 hours. 101, everyone. It is C, everyone. Perfect. Tomorrow 150. Okay, Piyush. I'll try to bring 150 tomorrow. Today 120, Guncha, I just mentioned. कितने भी केस लो पढ़ के कम ही होते हैं. हाँ जी बिल्कुल बिल्कुल everyone. I feel you totally. Okay. In which of the following cases the Supreme Court held that an electronic record by way of secondary evidence shall not be admitted in evidence unless the requirements under Section 65B are satisfied? Thus, in the case of CD, DVD, chip, etc., the same shall be accompanied by the certificate in terms of 65B obtained at the time of taking the document, without which the secondary evidence pertaining to that electronic record is inadmissible. 102, everyone. It has to be C again. ओके दोनों में से कोई भी क्वेश्चन पेपर में दिख जाए तो थोड़ा सा रोड लर्न भी कर सकते हैं, कोई चक्कर नहीं है, तो आप इसको मार्क कर सकते हैं. बोथ दीज क्वेश्चंस शक्ल याद रख लो उनकी बहुत है. ओके I understand how difficult is it, how overwhelming does it get to memorize all the case laws, and even if you memorize supposedly 50 of them, yeah, 100 of them, you never know 101st case law is going to come out of nowhere, so that's fine. Okay. Next question is on the screens, everyone. Which of the following types of evidence means testimony? Direct, circumstantial, both, none. Sandeep says it's B. Yeah. Go ahead. Knowledge Vista, I do not know your name, but whoever you are, go ahead. Puneet says A, Tanisha A, Harsimran A, Sneha A, Suman, Totu, Simran. Everyone says A. Perfect. It has to be direct evidence for you all. Okay. तो आगे चलते हैं. Instances. Does evidence mean? Okay, ये उल्टा है फिर से. Evidences mean facts. Okay. How do we decode it now? Does evidence mean a fact which is to serve as the foundation for an inference? Okay, we can you remove the word instances, right? Does evidence, which evidence? ऐसे करके कुछ बनेगा ना यार? I'm unable to decode this question. In case you are able to understand, समझ तो आ ही रहा है, कहना क्या चाह रहे हैं, आप उसका जवाब दे दें. 104B, everyone. Okay. Okay. It has to be 104B, perfect circumstantial evidence. I'm extremely sorry for this mess up. I really checked all of them. I don't know how it will go. Which of the following means a fact to be proved? Fact to be proved. Quid probandum, modus probendi, both, none. 105. Simran says C, Piyush says B, Sandeep says A. Lot of dichotomy in opinion I see. 105. It has to be A, everyone. It is quid probandum. Fact to be proved is quid probandum. Which of the following means the mode of proving? This is a fact to be proved. Which is the mode of proving? Modus. I'm sorry, I didn't mean to reveal the answer. Okay, perfect. Next. Who drafted Indian Evidence Act? Easiest question of the lot. Who drafted Indian Evidence Act? 107. ओके ये तो किसी का गलत नहीं है ना. आई एम जस्ट होपिंग किसी का ये तो गलत ना हो ना. ओके जेम्स स्टीफन. The word evidence relates to documentary evidence, admissible evidence, oral evidence, none of the above. The word evidence relates to 108. Options are not up to the mark in this question. No? We'll go with admissible evidence in this case. Admissible evidence for you all. Options are not up to the mark, but it had to be all of the above, right? So we're going with the most appropriate, which looks at least dicey है यहाँ पे तो बिल्कुल ही. We'll go with admissible. Point out the incorrect answer. Evidence may be direct and indirect, primary and secondary, oral and documentary, procedural and substantive. Point out the incorrect answer, it says. Evidence may be 109. Somebody says C, D. 109 has to be D, everyone. Very easy. Evidences थोड़ी होते हैं, laws होते हैं ना. Evidere means to show clearly, ascertain or signify. Evidere 110. 110 B. Okay. Suman, Rachna, Anjali, Vaishali. To show clearly. Nidhi says C. Okay, the answer has to be to show clearly, everyone. The answer is B. Which of the following sections of Indian Evidence Act is based on the principle that evidence has to be weighed, not counted? Easy question, good question it is. It is 134. I'm sorry. Oh. It is 134. I already mentioned. I'm sorry. Okay. Okay, perfect. It has to be B. 134, everyone. Perfect. In which of the following ways may the credit of the witness be impeached? By the evidence of persons who testify that they, from their knowledge of the witness, believe him to be unworthy of credit, by proof that the witness has been bribed or has accepted the offer of a bribe or has received any other corrupt inducement to give his evidence, by proof of former statements inconsistent with any part of his evidence which are liable to be contradicted, all of the above. How can a witness be impeached? Credit of the witness be impeached, everyone. 112D, do you all think? Okay. Okay, okay. Perfect, everyone. It has to be D. 112D. Okay. Next. Which of the following provisions of Evidence Act was omitted by 2002 Amendment Act? Okay, Rachna, actually the options were very, question was huge and I had to change the page. This was the question, Rachna. In case you want to screenshot it, I'm definitely going to give you a number. You're going to like obviously text there and I'm going to provide you the PDFs. Which of the following provisions of Indian Evidence Act was omitted by Amendment Act of 2002? It has to be C, everyone. C is the most appropriate answer. 155 clause 4. We are moving. We are nearing the end of the session, everyone. Please be a little more patient for next 6 questions. No person who is or has been married shall be compelled to disclose any communication made to him during marriage by any person to whom he is or has been married, nor shall he be permitted to disclose any such communication unless the person who made it or his representative in interest consents, except in suit between married persons, proceeding in which one married person is prosecuted for any crime committed against the other spouse, either A, B, C. 114. Sandeep says D. Harsimran D. Puneet D. Tanisha D. Nidhi D. Simran, Suman, Bhavya, Sneha. Everyone says D. Perfect. It has to be D. Okay. We move ahead now. The court may presume that if a man refuses to answer a question which he is not compelled to answer by law, the answer, if given, would be unfavorable to him. This is a presumption contained in section which clause of Indian Evidence Act says this. Sandeep says B. Tanisha says D. Sneha says B. Piyush D. Bhavya C. This one has to be 114H, everyone. 114H for you all. Deepak, accused of committing the offense of supplying arms, informs his lawyer Shweta that he has committed the offense and wishes her to defend him. In these circumstances, Shweta is duty bound to inform the police. Shweta is duty bound to inform the fact to the magistrate. The communication is a privileged one and protected from disclosure. The criminal court can, at the instance, compel Shweta to disclose the fact. All of you. 116. C. Okay. B. Sandeep says B. C. Piyush C. Rachna A. Piyush C. Okay. Okay. The answer in this case, it is 116. Has to be. It has to be C, everyone. Conversation between an advocate and the client is protected. A agrees absolutely in writing to pay rupees 1,000 on 1st March 1873. The fact that at the same time an oral agreement was made that the money should not be paid till 31st March. It can be proved, it cannot be proved, depends, none of the above. Good question. Okay, I'll check. 1158. No, it is H, I think. Please check for me. I don't have my Bare Act with me. Rachna or Toto TV, whoever commented, please check. Okay, 117. A agrees absolutely in writing to pay rupees 1,000. 117 का सबको क्या लगता है? B A मिक्स कंफ्यूजन चल रहा है. Cannot be proved. The answer, most appropriate answer would be B, everyone. Okay. Section 57 of Indian Evidence Act is exhaustive, illustrative, inclusive, none of the above. 57. Exhaustive, illustrative, exclusive, none of the above. A B में confusion चल रहा है. The answer has to be B, everyone. It is illustrative in nature. It is not exhaustive. Important question, I'd say. The admission of a party to an attested document of its execution by himself shall be sufficient proof of its execution as against him. If it is not a document required by law to be attested only, though it is a document required by law to be attested, if it is not a will only, none of the above. Second last question. Sandeep says A, Tanisha says B. Be quick. Have you all lost track? Okay. Confusion, Anjali. Okay. The answer of this question has to be B, everyone. Please note it down. Next question, last question. What is next? It's last. If the attesting witness denies or does not recollect the execution of the document, its execution. If the attesting witness denies or does not recollect the execution of the document, its execution cannot be proved, may be proved by other evidence, may not be proved by other evidence, none of the above. People are saying B, 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 B. Okay, 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 okay. Perfect, everyone. The answer to this question is D only, may be proved by other evidence. Perfect. Okay. Yeah, I am going to provide you the contact number, right? I'll do that right away. Before that, I want to discuss one question which I had in my head. I could not put it here. I hope you all know that falsus in uno. Achha, okay, the question is the falsus in uno is falsus in omnibus. Is this applicable in India? Okay, it is mentioned in the comments. Perfect, Puneet. Perfect. Please, everyone, it is a humble request to all of you who wanted the contact number. Please take it from the comments. It's dropped there. Not applicable in India. Perfect, everyone. It is not applicable in India. Do you know the case law Mahindran versus State of Tamil Nadu, latest 2019? It is Mahindran versus State of Tamil Nadu 2019 Supreme Court. Note it down for yourself. Falsus in uno is falsus in omnibus is not applicable in India. False in इसका मतलब क्या होता है? False in one is false in all. We do not apply this in India. Mahindran versus Tamil Nadu, it is 2019 for you all. Okay, yes, yes. Perfect, Sandeep. I am just hoping that you all enjoyed the session. I will come with more questions tomorrow as per the demand. I think I'll have to come up with 150 questions for tomorrow. I am planning. So before that, I would like to tell you that tomorrow morning around 9:45 a.m. you are going to obviously watch on YouTube live a free session that is going to be conducted by Dr. Kanupriya Grewal. You are going to love the constitution by her. What is she going to do is she's going to obviously cater according to Haryana only in one-liner format. The revision is going to be according to one-liners. Entire constitution of India is going to be covered tomorrow morning 9:45 a.m. everyone. I hope you all join the session right there and prepare well for your preliminary exam. And yeah, that is all for today. Please do comment below if you like the session. What all improvements do you want me to make? And what all amendments are required? And everything that whatever your requirements are, which subjects do you want? What should be the next subject? Please comment down below. I'll cater to all the comments. Thank you very much. Take care of yourself. Good night. Thank you to all who joined. Which subject will be taken up tomorrow? Bhavya, thank you, Anjali. You are just too kind. Thank you, everyone. Okay, thanks. Thank you, everyone. I am a little skeptical. I think I'll be taking, maybe we'll plan SRA with limitation. I think I'll take two minors tomorrow, as far as I know, because you have one heavy subject in the morning, which is Constitution of India. We'll see. I'll definitely drop a text to you. We'll obviously schedule a live class. You'll get to know which subject is going to be there tomorrow. Piyush comments 5, 6 times in a row. Okay. Thank you, Sandeep. Will I okay? I'll talk to the authorities if CRPC works for tomorrow. Otherwise, CRPC दो तीन दिन में आ ही जाएगी. No problem at all. ठीक है. I'll take your leave, everyone. Thank you. Thank you. Thank you. Please engage in the comments as well. Thank you. Okay. Bye bye.